People v. Brenda WW. Counsel?
Good afternoon, Chief Judge Wilson, fellow judges, opposing counsel Reed. My name's Sam Rogers from Madison County, representing the people of New York. May it please the court. If I could please reserve 2 minutes for rebuttal.
Yes.
This case is about the standard of review for DVSJA eligibility hearings and the required post-release supervision for those granted relief. I'm not here to attack the law, but instead to give it structure to do what's intended, which, as a threshold matter, is determine which criminal defendants merit relief based on their status as domestic violence survivors.
So, counsel, in your view, what, if any, are the limits on the appellate division's review of the court's decision below?
So the limits would be the appellate division has to apply an abuse of discretion analysis to the DVSJA eligibility determination.
Why is that?
Because the eligibility determination is not a sentence. It's
No,
a
why do they
threshold.
have to apply an abuse of discretion standard as opposed to some more de novo review power?
So as the court wrote 3 months ago in Brisbane, a abuse of discretion analysis is for those questions that are so inherently unsusceptible to broad generalized rules that it would not make sense to give the lower courts
The appellate division,
clear.
the appellate division has fact-finding power, no?
The appellate division does have fact-finding power depending on the type of review that they're doing. So my argument is that when it's conducting an abuse of discretion review, which
But that sort of has the cart in front of the horse. Why here is it not just ordinary fact-finding power?
because here it's not a sentencing proceeding that invokes the plenary sentencing broad review power of the appellate division. It's one that's being reviewed for abuse of discretion where to substitute the legal or factual matters of the lower court, the
Is the appellate division's factual review power limited only to sentencing? I feel like it applies in a whole range of contexts. In fact, I think the number of cases where they have to apply a deferential standard is probably far fewer than the ones where they have plenary factual review power. Would you not agree with that?
So I would agree that the appellate division has fact-finding power, but how they utilize that power and then the framework in which they apply that power.
And can they substitute their own judgment for that of the trial court?
In which scenario?
The
Your
appellate
Honor?
division, do they not have the power to decide to utilize their discretion and substitute their judgment for that of the trial court?
They can substitute their judgment for that of the trial court, which I would argue is when an abuse has occurred, which, again, going back to the abuse of discretion, it's not just whether the appellate division disagrees or another outcome would be reasonable. It's whether the lower court in this instant abused its discretion.
And where are you
which-
finding that standard? What's your authority for that? And is there anything in the DVSGA that suggests that the legislature was looking to curtail the appellate division's factual finding review powers in any way?
So the DVSJA in the legislative history and the plain language of the law clearly commits this power to the hearing court. That there's specific writings so under 440.47 GNF, that's where the lower court is making its decision whether this applicant warrants relief or doesn't. It says if the court determines. So it's giving explicit discretionary power to that county court.
And you're
It's not-
saying with respect to the appellate division, their fact reviewing power is somehow limited? Is that what you're suggesting?
So I would suggest that they can still review the facts, but as they apply those facts, they have to apply it and give some discretion.
Okay,
to-
do they not have the right to find their own facts at the appellate division?
So I would separate that into two different camps. So if they're doing their interest of justice review, which I don't believe is proper here, they can find the facts without any discretion to the lower court's determination. If they're doing an abuse of discretion review, when they're reviewing those facts, they're looking for whether the lower court was reasonable in their determination of the facts, and if the appellate division finds its own facts, it's still applying it to a heightened standard of review, because here in the law, it was given to those hearing court judges very explicitly.
In People
And-
v. Rickert, we said that the appellate division has the power to make new findings of fact and substitute its discretion for that of nisi prius, even in the absence of abuse.
So in that case, I would argue that the finding of facts that the appellate division does still has to apply to a heightened standard of review based on the law and how DVSJA creates the complete discretion of this lower court.
Just to be clear, what's the heightened standard of review?
So it'd be the abuse of discretion review.
see. Okay.
And what's clear in this
But
case,
I guess I'm having some trouble understanding how that layers over their fact-finding authority. So if they have fact-finding authority, to me, this seems much like a YO determination, right? And I think we affirmed the case where the appellate division said, we've weighed all the factors and we don't feel the trial court abused its discretion in denying YO treatment, but we choose to exercise our discretion and do it. So, and we said that was okay. We affirmed that case. So why isn't this like that?
so I think it is similar to a YO determination, and the difference being, in this case, the court explicitly wrote it's invoking and making its decision based on 470-15-6B sentencing, plenary sentencing review. When you review YO cases, it's reviewed. If it's overturned, it's remitted back to the trial court to then impose a sentence. That's what should have happened in these cases, in DVSJA cases.
Well,
because again,
in YO cases, the appellate division doesn't have to remit back. They can substitute and grant YO if it was denied.
Well, yeah, so, Your Honor, I would say that the appellate division can grant YO if it was denied, but then the remedy in that scenario is to remit back to the local court. And that's what the court did in the case People v. ZH, which was cited in Brisbane, where the appellate division explicitly said this is not an abuse of discretion.
Correct.
We're going to invoke our interests of justice. We're going to grant YO, remit back to the county court for sentencing, because then that case goes back, there's a sentence imposed.
But
and then
it's consistent with the determination of the appellate division.
Correct. But
And in this particular instance, are you suggesting somehow that the trial court's decision is not reviewable?
No, so I'm suggesting that the trial court's decision is definitely reviewable under an abuse of discretion standard. And if the appellate division finds that an abuse of discretion took place, it can reverse that DVSJA determination, remit it back to the county court in the same way that it would in a youthful offender, and then the county court gets its first turn at imposing a sentence, and then even if a sentence is imposed under DVSJA standards, then it can be reviewed based on 440-47-3B as unduly harsh or severe or illegally authorized. So in this case, what should have happened is the Third Department erroneously used plenary sentencing power when that power was not invoked. This court has written recently and pretty extensively on how to apply sentencing power. I think this case demands clarification on when to apply it, because it was clear that the court invoked under 470-15-6B this sentencing power where it wasn't a sentencing question before the court.
So your view would be, even if they had this authority, which is very limited in review to this court, the proper remedy here was remittal for sentencing under the statute, and then they could review that for unduly harsh and excessive?
I would say yes, that's the only remedy that's available, is to remit it to the local court. But again, I would say under the abuse of discretion standard versus, so the court deployed interest of justice standard. That's very clear in what they wrote and how they conducted it.
Can we review interest of justice?
You may review whether it's the correct standard to apply. And I believe the cases starting as early as I've seen with Thompson in '83, then Delgado in '92, up until Brisbane in January, the court will, even if the appellate division says it's interest of justice, the court will zoom in, double click, see what review was actually done and whether it was done correctly.
Where is it in the appellate division you would point me to demonstrate conclusively that the appellate division thought it was exercising its interest of justice jurisdiction to decide this.
So in this case, it would be the majority in footnote 2, and then.
So that footnote seems to me to say, we, the appellate division, previously decided this sentence wasn't harsh and excessive, but we're not constrained when we're acting under the statute by our prior determination on prior appeal that it was not harsh and excessive. It actually seems to me the opposite of what you're saying.
So I don't know if I understand your question, but I would agree with the appellate division that they are not restrained to then review a DVSJ eligibility determination based on their prior direct review of an unduly harsh and severe sentence, because it's two completely different questions.
Right, and it seems what they're pointing to is that the statute gives them authority to do this despite their prior interest of justice determination on harsh and excessive. It seems to me they're not saying they're relying on the interest of justice jurisdiction of the footnote.
I would disagree with that, Your Honor. And I think with what they said, and then the dissent clarifies in its footnote 5, where it says, I agree with the majority based on our broad plenary sentencing 470-15-6B, we do not have to find an abuse of discretion. I would actually argue that the majority and the dissent in that vein are wrong. They do have to find an abuse of discretion because, again, it's not a specific sentencing question that they're reviewing. And that can be seen based on what the respondent in this case appealed. The respondent appealed an order denying resentencing, not the sentence itself. So there was no sentence before the court to invoke unduly harsh or severe review. What it had to do was analyze the findings of the lower court for an abuse of discretion. And if it does that, there's certain facts that it just completely overturns and then applies to this interest of justice broad sentencing and reverses. So
I think the court was actually invoking another standard, and they said they were looking at the record and using a preponderance of the evidence standard. So I don't know where you're getting an interest of justice standard. They explicitly say we find defendant established by a preponderance of the evidence, et cetera.
So preponderance of the evidence is how the appellate divisions have determined that an applicant must show each of the DVSJA prongs. That is their burden of proof. The appellate division invoked its standard of review, which I argue was interest of justice. I'll pivot now to my second point, that post-release supervision in DVSJA is required. And I would somewhat amend my brief where it was not completely eliminated in this case. What the court did was credit the time that this respondent spent in prison towards the post-release supervision.
And what's your response to the AG's letter?
My response to the AG's letter is that I believe the AG agrees that there's no statutory authority for this, and the argument was it's just how we've always done it, which to me is an argument. I don't think it's the strongest one, where there's no statutory authority in DVSJ for that. There's also, notably, DVSJA amends the penal law, Article 70 and 70.06, to amend post-release supervision, and also gives time credit for time spent in jail, but doesn't give any time credit for post-release supervision. I think post-release supervision is not just punitive. There are rehabilitation aspects to it, a lot of services that somebody could benefit from, especially DVSJA candidates. So with that, I will cede the rest of my time for rebuttal. Thank you.
Thank you.
Good afternoon. May it please the court, Veronica Reed for Brenda WW. A showing of an abuse of discretion.
What's the standard, and is it different at each of the prongs, the three
Okay.
prongs?
Your Honor, the standard for an inquiry into whether a sentence was unduly harsh is the appellate division's jurisdiction, which is to have original fact-finding jurisdiction and also to not have to defer to the lower court, the sentencing court's determination. It's established by the Constitution. It was codified in the CPL, and that in Brenda WW, both the majority and the dissent were both specific in stating that they were exercising their broad interest of justice jurisdiction in reviewing the sentence, and that notwithstanding the discretion afforded the hearing court, they did not need to find.
So at the last step, if they get that far, it's interest of justice. What about the first two?
So the structurally, the people are arguing that because there are these prongs to the DVSJA, that somehow an abuse of discretion standard gets triggered. That's not the case. The DVSJA is a sentencing statute. It is not structurally the same as a statute where the abuse of discretion standard would apply. This was one of the things in the Brisbane.
No, I'm sorry, what is the standard from your vantage point?
The standard for the DVSJA?
For the first two prongs, you told me the third one is the interest of justice. Are the other two also interest of justice or something else?
Yes, because the prongs are connected with ands. So subsection 1 has an A, a B, and a C. Those aren't connected with a then, which the people are arguing that there's a then, that you have to find the A, and then you have to find the B.
Let me ask it this way. So A is, at the time of the offense, the defendant was a victim of domestic violence, subjected to substantial physical, et cetera. County court looks at the record, hears the testimony, says no. They make a factual finding that at the time of the instant offense, the defendant was not a victim of domestic violence. Goes to the appellate division. They have the record, they have the county court's finding on just A, let's stick with A, victim of domestic violence. What standard do they apply? What standard does the appellate division apply in reviewing the county court's finding as to A, victim of domestic violence, which seems to me a factual finding?
It's the interest of justice because the prongs aren't separate. The prongs are similar. The statute is similar to the YO statute. Now, in the YO statute.
But if you think that, then
Right.
we can't review this at all.
Yes, Judge.
That's your position.
Well, we made our jurisdictional argument, and we do maintain our jurisdictional argument that that this court doesn't have jurisdiction to review Brenda WW.
Well, we have power to review whether or not they applied the right standard, right?
Right, correct.
So your view is all of the fact-finding by county court is interest of justice when it goes to the appellate division. They look at it, they can do, essentially, I think what you're saying is a de novo review using their fact-finding power.
Yes,
And
Judge.
make a determination whether the burden was met for each prong.
Yes, Judge.
And then it seems to me that final step, where even if you meet the three prongs, you can do this or not do it, is a pure discretionary exercise, right?
Right.
You can say, yeah, they met the three prongs, but I still don't think you should get this relief. Or you can say, yes, you should. What's the standard if county court says, no, yes, you met the three prongs, but it's a discretionary call at the end, I'm going to say no. What's the appellate division authority to review that ultimate decision?
It's the same authority, Judge. It's the same original interest of justice jurisdiction. And in fact, that's what happened in Brenda WW between the majority and the dissent. So they're exercising their same fact-finding ability as the sentencing court judge. The entire bench actually agrees all the way through until you get to do the fact support finding that the sentence is unjust. The majority decision says it's a close call, but based on the history of the violent relationships, that they're going to find, based on the totality of circumstances, that the sentence is unjust. The dissent says They wanted to see remorse, and they didn't feel the factual record supported remorse sufficient to reduce the sentence.
So I just want to be clear, in your response to the question Judge Garcia argued, even that determination would be beyond our review if the appropriate standard is interests of justice. Is that right?
Yeah, well, our argument is that Brenda WW didn't raise an issue of law, and so, ergo, no jurisdiction for the Court of Appeals. Further, it was a mixed issue of fact and law, and that...
I think Judge Kanachar was trying to get something a little different. So suppose we agree with you, right, that that everything here that the Appellate Division is doing in reviewing DSJVA applications is on interest of justice, right? Once that standard is determined, then none of these will ever be reviewable by the Court of Appeals for anything. Is that right? As long as you're using that standard.
Yes.
So your interpretation of the statute is it's meant really not to have any review by the Court of Appeals once the correct standard is determined.
Yes.
If the standard is the one you're advocating.
Yes, unless there's an error of law, similar to...
Well, what could the error of
What would
law
be the
be?
As a defense counsel, I always want to leave that opening. But it's very similar to if...
Well, what could an example of an error of law be?
Well, I would say the DVSJA interest of justice finding, if the appellate division finds yes, sentence unjust, no, sentence unjust, then it's the same conundrum as if I had done a harsh and excessive...
No, but let's take the first prong, for example.
Right.
That is, there's absolutely no record evidence of any domestic violence, and the appellate division says we find this first prong satisfied, right?
Right.
Under your view, because that was done under interest of justice jurisdiction, we can't review that at all, even if there's no evidence.
Because the prongs are criteria similar to the YO criteria. So
It seems,
it's...
to follow up on the Chief Judge, is what I was trying to get at earlier. Those first three prongs, to be, at least the first two, seem like factual determinations.
Right,
And usually, if that happens, we don't have fact-finding power here, obviously.
right.
But as the Chief Judge was saying, we do have the authority to look and say, you made a factual finding and there is absolutely no support for that in the record. Would we have that authority here under your review standard?
No, because they're not threshold questions. You don't...
So if they're not threshold questions, what are they? You cannot get to the third prong if you haven't walked through the first two. Or do you think they can always jump to the third prong, don't even waste their time on the first two, if their ultimate conclusion is going to be, it's not unduly harsh?
They have to get to all three. They're ands between, the statute is actually written with an and between
Well,
A...
okay, but if
Right.
taking the hypothetical, if at the first
Right.
prong, they don't find that she's a victim of domestic violence,
Right.
why are they going about the business of considering the next two?
They're going to look at all three. If you don't get all three, if you don't achieve an A,
But
or you
the
don't...
but the
you-
point
then
is, if
don't
you
go-
haven't gotten past A,
Right.
why are you looking at B and C?
You're going to look at A, B, and C, and if you don't get any of those, if you don't get one of those,
I
you don't get
understand. Your
that.
point is you got to have all three for a resentencing under the statute. My
Yes.
point is, since you have to have all three.
Right.
If you don't have the first one, why are you even looking at the other two?
So
It's not, I don't view it as a holistic analysis other than the third prong in the same way I
Oh.
think you do. Each one seems to have particular, using your word, criteria
Right.
that the court has to consider in making its determination.
Right. I see them as holistic, that you have to have the three to reduce the sentence, because the DVSJ...
So if it's your position that if they fail at one and they fail at two, they cannot, in their interest of justice, reduce the defendant's sentence?
Not under the DVSJA, right?
So in that regard, it's not like, sometimes one will see a multi-factor balancing test. There might be 3 factors, they weigh in different directions, and so you might not do well on factor 1, but if you do great on factors 2 and 3, you might still get the result that you want. But I take it you agree that if you don't satisfy step 1, there's no need to go any further, and the same with step 2, there's no need to go any further.
Because the resentencing is under this particular statute, the application.
Under this statute,
right.
that's what I mean.
Right. And the idea, it's a domestic violence statute. So the legislature wrote it to say, if we're going to give compassionate relief to a domestic violence survivor, you have to be a domestic violence survivor.
So you start with the first step, and only if you satisfy that, you go to the second, and then the same with the third?
No, I think A and B have to be looked at together. I think you.
Let's say we disagree with you. Let's say we don't read it that way.
Okay.
If
Right.
we disagree with you,
Right.
what is your position regarding the standard?
It doesn't change the
It's
interest
still
of
interest of
justice.
justice, even if we disagree with you that this is not looking at all 3 simultaneously, but rather walking through them in a particular order.
Right, because it's still an and that connects them. It's not, it does not.
And why does the "and" justify the use of interest of justice jurisdiction?
It doesn't structurally,
Because the last step, in your view, is so clearly about interest of justice jurisdiction, so the other 2 must, of course, be about interest of justice jurisdiction as a standard?
yes. It doesn't structurally.
If we disagree with you about that, what is your default as to what would be the standard for steps 1 and 2?
I still would maintain that it's interest of justice, and I'd refer back to the discussion that happens in Adamando for that, right? Because when you look at the Adamando decision and the court is walking through, the Second Department is walking through the facts. The Adamando decision is all about the facts. And as the court is walking through the facts in the Adamando decision, it specifically says that the review of those facts, the review of A and the review of B, is going to lead the court to an interest of justice determination. They cite to Delgado, right? And the Second Department says, regardless of what the sentencing court did or the trial court did, in our jurisdiction as the appellate division, we're going to review the facts anew, and we're going to make our determination on whether the...
So your position is that regardless if there is a case, not your case, another case, there is clearly a record of domestic violence, yet the court says there's none, it will never get to the Court of Appeals.
So if the
You said everything is interest of justice.
Right.
So it never gets to the Court of Appeals, correct?
It would not get to the Court of Appeals, and
And so that person would have no relief.
the person has relief in the appellate court, which
The appellate division says no.
in their...
But the record says the opposite. You're saying that record cannot be reviewed.
There are going to be times when the review of the record is done with an error as a matter of law. For example, if the appellate court in its record review relies on a report or evidence or an interpretation of evidence that isn't correct as a matter of law, right? Then
But what does that mean exactly, that they rely on evidence that isn't correct as a matter of law?
what if they substituted their judgment for that of the psychologist?
Well, to take what I believe Judge Troutman's hypothetical to be, if there, I'm not sure exactly what you mean by an error of law, but if there is not what one might call an error of law, I take it your position is that there is no review by this court, even if the record completely belies whatever the appellate division says it does.
if the record belied what the appellate division said it does, I would think that there would be errors of law in that, right? Because errors of law are
Depends on what
related.
that means, I guess, I'm not sure.
But an error of law can come about through evidentiary errors.
Counsel, can I just go back 1 second to your question about how you analyze the prongs in the DVSJA? I'm looking at it now, and you seem to put a lot of weight on the word "and" how it joins the provisions, and I don't see an "and" anywhere in the statute.
The "and" is in between 1 sub B and 1 sub C. It says subdivision A1, there's
B,
comma.
as in such abuse was a significant contributing factor to the defendant's criminal behavior.
And then it goes to C.
I don't see that "and."
Oh,
Are you sure it's there?
I am not now, Judge. I apologize.
Your red light is on, but could I ask you to spend a minute on the PRS question?
Yes.
Because the statute does seem on its face to say that there's a mandatory term of PRS following a resentencing under the Act.
Right. And in this case, I went back and looked, in addition to the statute, but looked to the actual dates of things. So in a determinate sentence, PRS is a required sentencing piece. And that PRS period is actually, so if you're sentenced to 20 years determinate plus 5 years post-release supervision, the statute says that your sentence is the 25 years. And in fact, when you have that release at the 20 years to go serve your PRS, it doesn't work like parole. There's no technical or non-technical violation. If there's a violation during your PRS, you're immediately remanded back to finish your period of incarceration. So for all intents and purposes, PRS is incarceration, just not within the 4 walls of docks. In here, when the appellate division calculated Brenda's sentence reduction, the number of years she had actually served when she was released was 15. When we had the order for her release, we obtained that on December 22nd, 2023. Brenda's earliest release date would have been January 26th.
Well, it's certainly, yes, the new sentence on the resentencing, she's already served that time.
Right.
But wouldn't that seem that the legislature would have been aware, once it passed this statute, that there would be individuals like the defendant who would indeed have served so many years already in the past, right? That they will have exceeded the time, the incarceratory time under the resentence? One would think then they would indicate that PRS would not apply to such an individual.
It's my assumption that when the statute was drafted, that they were relying on statutory language for PRS that was already written.
But they made other amendments, you heard counsel, they made other amendments that would suggest that
Right.
this was either not an error, or this is not, what you're arguing is not what they intended.
Oh, I see, Judge. So why, is the question really is fundamentally, why didn't they just make an amendment to PRS to clarify, correct? I don't know. I think that they would have been relying on the PRS statute, which would have said it's part of the determinate sentencing, ergo, it's really a 25-year sentence as opposed to a 20-year sentence. And so if you're released, if your resentencing is for 8 years and you've already served 25, we're going to calculate that 5. PRS in its practical stance is supervisory in nature, but it is a period of sentencing. So I don't think that we should turn it into something it's not.
Thank you.
Thank you. Sorry.
The domestic violence
I'm
survivor.
sorry, counsel, just to quickly ask you, assume for the moment that this is some type of fact-finding authority, in at least the first two prongs. And that comes to us in this case, right? And our standard of review is limited to, is there support in the record or is there no support in the record? Can you point to anything that the majority in the appellate division found that is unsupported by the record under that standard of review?
I think the appellate division found and gave credit to a lot of discredited testimony in this case, whereas they relied many times on the defendant's trial testimony, which was rejected by the jury, or that the defendant had remorse, which was rejected by the sentencing judge. So I think there's plenty of facts in this case. I would also note that the last concrete spoken to domestic violent incident happened a year and a half before the crime in this case. All the other instances of domestic violence came from statements from the respondent, or they were spoken into the record from people who heard about it from the respondent. When you look at DVSJA, it was intended to empower local court judges to have discretion. That's highlighted in the statutory history and the conversations where almost every question was met with a hedge of, yes, but of course we're giving the discretion to the county court judge. I also want to highlight that it gives it back to the original judge who heard the initial proceedings. And that's about as far away from an appellate division court on the papers as one can get. When the appellate division here reviewed this case, they did so with the wrong standard of review. It should be an abuse of discretion. I would ask this court under its power under 47040 subdivision 1A to remit it to the county court to impose the original sentence. In the alternative, if you believe the facts have not been established, you can remit it to the appellate division to make a decision consistent with your finding. Thank you very much.
Thank you.